Hello, this is Lupita Mitz, designated broker with OMNI Homes International, and I'm going to talk about the additional clause addendum today. So let's talk about the purchase contract first. The Arizona Residential Real Estate Purchase and Sales Agreement. This is a legal document where the terms and conditions are set forth in regards to a buyer's interest in purchasing a piece of property from a person wishing to sell. The seller and the buyer negotiate terms of the agreement, including purchase price, closing date, property conditions, and so on. The basic terms are included in the 10-page document. However, there are situations that come up that warrant additional verbiage or clauses. Page 8 is provided for additional terms. Be careful when writing in this section. You must write in a clear and concise manner so that there is no misinterpretation or lack of information which could put your buyer at risk. ADRE has come up with an addendum to help you with the most common clauses that might be needed, and that is the additional clause addendum. So here's the additional clause addendum on your screen. Of course, you're going to write in the buyer, seller, the address, and the date. Following additional terms and conditions are hereby included as part of the contract between seller and buyer for the above referenced premises, if marked by an X and initialed by buyer and seller. All terms and conditions of the contract are hereby included herein, and delivery of all notices and documentation shall be deemed delivered and received when sent as required by Section 8M of the purchase contract. So let's start with the most common clause that you will need. If a buyer wants to make an offer on a property that is already under contract, you will use the backup contract contingent upon cancellation or prior contract clause. The buyer acknowledges that seller is currently obligated by a prior contract to sell the premises to another buyer. This is a backup contract contingent upon cancellation of prior contract. The seller retains the right to amend, extend, or modify the prior contract. Upon cancellation of prior contract, the seller shall promptly deliver written notice to buyer. On buyer's receipt of that notice of cancellation of the prior contract, and the buyer shall open escrow, and the buyer shall deposit any required earnest money. The date of seller's written notice to the buyer is deemed the date of contract acceptance for purposes of all applicable contract time periods. For example, your due diligence period would begin. The buyer may cancel this backup contract at any time prior to receipt of seller's notice of cancellation of prior contract. Signature of absent buyer, spouse, or co-buyer. Signing buyer shall, within 5 days, or you can write in a different number, of acceptance of this contract, obtain the signature of the absent buyer, spouse, or co-buyer on this contract, or deliver a disclaimer deed to escrow company that eliminates the need of the absent signature. Corporate relocation approval. Seller is in the process of a corporate relocation, and this contract is contingent upon corporate approval. Buyer agrees to cooperate with seller in providing additional disclosures or executing additional addenda required by corporation, provided that buyer incurs no additional cost or liability. Non-refundable earnest money. Buyer's earnest money shall be non-refundable unless buyer elects to cancel pursuant to the due diligence section of the contract. The contract is canceled pursuant to the risk or of loss provision, or escrow fails to close due to the seller's breach of contract. The buyer acknowledges that buyer's earnest money shall be non-refundable even if the premises fail to appraise for the sales price or the loan contingency is unfulfilled unless otherwise prohibited by federal law. So for example, a VA buyer, this would apply with them. The VA clause excludes this non-refundable earnest money clause. So a buyer that is going VA would get their money back if the property did not appraise. Waiver of appraisal. The buyer agrees to waive the appraisal contingency pursuant to the financing section of the contract. In the event that the premises fail to appraise for at least the sales price, buyer agrees that buyer's down payment shall be increased in an amount equal to the difference between the appraised value and the purchase price. An all-cash sale appraisal. All-cash sale appraisal contingency. Buyer's obligation to complete this all-cash sale is contingent upon an appraisal of the premises for at least the purchase price. So remember that on a cash sale, the financing section, section 2, is skipped. So the provision for the contingency of the appraisal is out, and you have to write it back in. If the premises fail to appraise for the purchase price, the buyer has 5 days after notice of the appraised value or 20 days after contract acceptance, whichever occurs first, to cancel this contract and receive a return of the earnest money, or the appraisal contingency shall be waived. In all cases, this appraisal contingency shall expire 20 days after contract acceptance, regardless of whether an appraisal has been ordered or received. Appraisal fee shall be paid by, and then you choose buyer, seller, other. Survey. There are several different surveys that can be requested, and a land contract has this provision already, but a residential contract does not. So if the buyer is looking for a survey, you would use this clause. A survey shall be performed by a licensed surveyor within, write in how many days after contract acceptance. The cost of the survey shall be paid, and then elect buyer, seller, or other. The survey shall be performed in accordance with the Arizona State Board of Technical Registration's Arizona's Land Boundary Survey minimum standards. And then you can pick the survey instructions. The boundary survey and survey plat showing the corners either verified or monumentation. A survey certified by a licensed surveyor acceptable to buyer and the title company in sufficient detail for an ALTA owner's policy of insurance with boundary encroachments or survey exceptions, and showing all improvements, utility lines and easements on the property within 5 feet thereof. Buyer shall have 5 days after receipt of results of survey or map to provide notice of disapproval to the seller. Tax deferred exchange. Either the seller or the buyer intend to enter into a tax deferred exchange pursuant to IRC 1031 or otherwise. All additional costs in connection with any tax deferred exchange shall be borne by the party requesting the exchange. The non-requesting party agrees to cooperate in the tax deferred exchange, provided that the non-requesting party incurs no additional cost and close of escrow is not delayed. Parties are advised to consult a professional tax advisor regarding the advisability of any such exchange. The non-requesting party and broker shall be indemnified and held harmless from any liability that might arise from participation in a tax deferred exchange. Water. Arizona is undertaking general stream adjudications of both the Gila River and the Little Colorado River systems, which are court proceedings to determine water rights. If the premises property is affected by an adjudication, the parties shall execute and file an assignment of statement of claimant form, and buyers shall pay any associated filing fees. The Arizona Department of Water Resources and the Arizona Department of Real Estate Buyer Advisory provide sources of information on the court proceedings and other water availability of water quality issues. If water rights, availability, or quality are a material matter to the buyer, these issues must be investigated during the inspection period. This entire form can be added to your contract, or you can select one of the clauses that applies, cut and paste, and add it under additional terms on your purchase contract. If you use this form, the undersigned agrees to the modified or additional terms and conditions contained herein and acknowledges a copy hereof. Buyer and seller sign, it becomes part of the contract. And that is it. No clause addendum.